Cleveland County, and Mr. Smith, whenever you're ready, we'd be pleased to hear from you.
Thank you, Your Honors. May it please the court, my name is Chris Smith, and I have the privilege of representing Southern Power. This, Your Honors, is a simple case, and I'm going to focus my remarks on one essential point: the effective date. Southern wins because the effective date of this agreement, which is an essential term of this agreement, and I'll explain why, particularly in this context, it's essential, is July 24, 2007, and subsequently enacted laws do not apply here. But before going into that essential point about the essential effective date, I'd just like to make some table setting comments, if I may. Southern Power is a good citizen. It values its relationship with Cleveland County. It values its relationship with all governments where it operates. It does not want to be here, frankly. And I think that comes through in our papers, that we have done everything possible to avoid being before Your Honors here today. But we had to be here. We must honor what the commitments made to our owners. Everyone knows, everyone in this courtroom involved with this case knows that Southern did exactly what it promised it would do, period, full stop. As we noted in paragraph 71 of our complaint, all that has changed since Southern did exactly what it promised it would do is that there has been a change in the county commission and there has been a change in the county manager. We respectfully suggest that
there's been a change in the law too.
A subsequently enacted change in the law, yes, post-dating the effective date of the parties' agreement. And it is...
I don't understand, well, I want you to explain to me why the effective date is the relevant date for your argument. I mean, is it your position that parties can enter into a contract and then backdate it to avoid new laws? I mean, could you and the county today enter into a similar contract knowing it was inconsistent with subsection H, but just backdate it to July 2007 to avoid the application of subsection H?
No.
Well, why not if the effective date is what governs?
Well, I think that if you have a government entering into a contract that is disabled by law, you can't, through freedom of contract does not take you that far, that you could contravene a public policy, which a statute reflects.
Isn't that what you're saying you did?
No, Your Honor. And if I may explain why that's the case, we don't need to go to subsection H, although we do win if we go to subsection H. But let me just focus, if I may, on the simple issue of the parties agreed to July 24, 2000.
Couldn't it be said that one of the threshold issues here is whether there was a contract in the first place, and it's termed an agreement, and I wonder whether it's a contract or whether it was just an agreement to agree. Then you put it, sometimes it's you say it's a unilateral contract. I have a question about that because I thought the basic nature of contract was bilateral and that there was a meeting of the minds. But one of the things that concerns me, I think you have a pretty good equitable case, Mr. Smith, but I'm not certain that you have a strong legal case as you might have made. And what concerns me is that in this initial agreement, I wonder if you protected yourself adequately because you didn't make any commitments. You didn't say that you were obligated to construct the power plant. You weren't required to invest any funds in the site, and the construction decision was left to your sole discretion.
Yes, Your Honor.
And you have, but what I'm saying is, so many terms here were simply left for you to fill in the blanks, and according to the way you wish to do so. And so what I'm wondering here is whether we really have an initial contract. I'm sympathetic to the equitable argument you're making, but as far as the law of contracts, I need you to help me out.
Yes, and if I may, Your Honor, focus directly on that point and push back on any concern that there is in fact a valid contract here. There's a lot going on here. And yes, I do think the magistrate below was misled by the invocation of unilateral. Yes, there's a unilateral concept here, but what we have is an agreement where the parties agreed on the effective date. I'll tell you why that's critical, why it's called essential in just a moment. But there's also a fair amount of action in this contract by a lot of, yes, Your Honor.
If you could clarify for me, when do you think there was a contract? When was the contract entered into?
The contract was entered into effective July 24.
Not when it was effective, like at what moment did there become a contract in your
July
view?
24, 2007. And the county became obligated to pay us our incentives once we reached commercial operations date under the incentives agreement. And if I may, Your Honor, just walk through the court.
Before you start to walk through, do we agree there are three elements in a contract? Offer, acceptance, and consideration?
Yes, Your Honor.
What was the consideration?
Well, the consideration is the relationship that is embraced in the incentives agreement. And we clearly have two parties together making mutual promises to each other. There are bilateral components from the get-go, from day one. I would direct the court to paragraphs.
The problem is, whether this is a contract, it seems to me that there are just so many terms, vital terms to be filled in. And if there are that many vital terms to be filled in, I have a question whether there's a meeting of the minds or whether we have an agreement possibly to agree. But isn't it vital the day that construction was going to start, or when it was going to be completed, or what investments or funds were going to be made in the site? What threshold amount was going to be required before Southern could receive payments? In other words, this kind of contract in the business world is normally very detailed.
Yes, Your Honor.
And the parties negotiate these fine points, and it's just not left as loose as this. I understand your point about the fact that you went ahead, you thought you were going to you started construction, you started paying taxes at a certain point, you thought you were going to get these payments, but the question is, did you do enough to protect your position at the outset? I mean,
yes, Your Honor.
And sophisticated business, as a sophisticated business entity, there's some obligation of self-protection, and I just don't know whether you've done that. So help me out.
Yes, Your Honor. And here is how that works. And this is how these agreements work when you're partnering with a government. The essential piece to be done here, and the only really remaining big piece, was the construction of at least a 50 megawatt power facility. 50 megawatts is mighty big. It's a mighty big expenditure. We built a 720 megawatt facility pumping more than $300 million into the ground in Cleveland County. This is not a spec project. This is not, if you build it, they will come. And the county, I encourage the court to look carefully at the complaint and the record where the county acknowledges this, that Southern can only do this if it is able to secure the agreements for people to buy the power. We don't come in, spend $300 million, take 5 years doing it, and then say we're open for business. That is not the way.
I don't think anybody is suggesting that. Remember, we started with where the effective date is.
Yes.
Okay, 2 weeks after that effective date, you can walk away from the contract. There is nothing that prevents you from doing that. There's no liability to you, right?
Well, I think at that point, both parties would have a claim for reliance, taking actions on the agreement. There are bilateral promises, things that the county is undertaking. There's activity from the effective date all the way until when
Maybe activity, but is there activity that you have contracted that you will not take that can be enforced by this agreement? And I would suggest that there just isn't.
There is detrimental reliance, but yes, it is a clear term.
Only if this is a contract can you claim detrimental reliance. It's an agreement that does not have contractual force.
Well, Your Honor, the parties walked into this knowing that it can only happen if Southern is able to secure the power arrangements and contracts with customers, which it did not have.
Can I ask you just a follow-up question? Because I really do want to understand your argument. Just following up on Judge Motz's question, just assume hypothetically that as I read the contract, there would have been nothing to stop your client from walking away in 2 weeks after signing this agreement and just saying, doesn't say we're going to build a plant and now we're not going to build a plant. If I think that is the only reasonable reading of this agreement, how does that affect your argument? Do you have a fallback argument other than actually we were required to build this plant starting on the effective date?
It can work exactly that way, Your Honor. And in fact, 2 weeks after July 24th, Southern could have said, you know what? We tested the market. There is no way we're going to be able to get the power contracts to justify putting $300 million into the ground. The parties knew this when they shook hands, and they knew and they wanted Southern to go get those agreements. Southern was able to secure the agreements such that it knew the economics of the investment would work. Your Honors, I would, and I do want to reserve time for rebuttal, but I would suggest to the court that this is a basic capital infrastructure investment agreement done widely, different forms.
Another agreement that had the same situation as this one, that is that we had this statute or
subsection H
enacted shortly after the contract, making the contract illegal.
I'm aware of
agreement.
I'm aware of no such case, Your Honor. I don't have another incentives agreement in the
It doesn't have to
record.
be. It could be any kind of agreement that has the same kind of provisions in it that do not have an immediate obligation on either party's part.
Yes.
And you don't have one, right? Who drew this contract or this agreement?
Well, it was negotiated by both parties. The law
that.
firm was the Sanford Holzhauser law firm for Southern at the time. It's on the agreement, but it was negotiated by the county's attorneys. But if I may, Your Honors.
It was Southern's law firm that wrote it, right?
They're on the front page. There is not in the record, who cranked out the first. That would be my assumption.
You're Southern's lawyer, so you know who drew the contract, right?
Well, I wasn't involved respectfully, I was not involved in the negotiations.
I do understand that,
Yes.
but this is your client. When you go into your client, you don't say, don't tell me anything about what happened. So you know who drew the contract.
Yes, it's not in the record. And frankly, I didn't ask the client, but my assumption is it says prepared by Sanford Holzhauser, but it was negotiated. Who's Southern's lawyer? Yes, Your Honor.
That's the part I did.
Yes. But it's a negotiated agreement. And Your Honor, what I would suggest to the court that is a very important concept here is that capital infrastructure agreements, this is how they're done. The county's position is essentially, as of now, everybody was very happy before. We have a subsequently passed ordinance after subsection H saying, yes, there is a contract. The county said that. There is a freedom of contract. That's this court's 7 Peanuts case that recognizes the ability of the parties to agree to what will work for them, what would work for them here, and what everyone shook hands on firmly. What everyone agreed to was, Southern, we love you, we want you here, we understand we can't get you here unless you can secure the power contracts. See if you can do it, and we know if you can't, you can walk, because they're not going to make that investment unless they can get, and that's what everyone agrees to.
But nonetheless,
that's contract.
If Southern does this, we are on the hook and we can't walk. Is that what you're saying? That seems like a very odd contract for the county to enter into. But what I like, and this is my time, so don't worry about going into your rebuttal.
Thank you, Your Honor.
Okay? Because this is an important case that we want to get right, involves a lot of money for your client or the county. Can you tell me what actions in reliance on this contract you took between July 24, 2007 and the day when Section H was passed, which is what, a month later?
So it is not in the record for me to be able to say the specific acts. But
were there any specific acts?
So I can't represent to this court specific acts, but I will, Your Honor, what it flows from the record and its inferences in Southern's favor, that they talked a long time about this agreement. The county knows that Southern needs to negotiate the agreements, do preliminary work. A 720 megawatt plant takes years. Once they struck a deal, July 24th, it was off to the races, and they were able to secure all the agreements needed in order to make it economic and come back to the county and say we're ready to go.
Section 8 was enacted?
We did not know. All the agreements were not secured before.
Was anything done before Section 8? Was there, if you point to anything?
And well, Your Honor,
you're telling me they worked hard on it?
Yes. Your Honor, that is my representation to the court, that all that period of time would involve the work needed in order for Southern to be in position to say, yes, county, we can do this, we can make this work. And Your Honor, to answer your question directly.
At what time did you actually fulfill the requirements set forth by subsection H? I mean, where you promised or whatever, or either performed to maintain the specific level of job creation and the capital investment over time that subsection 8 requires. At what time do you contend you were in compliance with subsection H?
Well, again, I know the court appreciates that we don't need to comply with subsection H, but those provisions that's our initial position, Your Honor. But we win under subsection H because the provisions under subsection H, talking about the amount of investment, the number of employees, those are not mandatory provisions. And I would direct the court to our briefing on that. They're not mandatory provisions, they're guidance. You could never have a purely capital infrastructure agreement under the county's after the game construction of subsection H. You could not have Google come to North Carolina and build a server farm, which takes, a handful of employees. It wouldn't work. And Your Honor, Judge Motz, I want to answer your question directly about, well, could the county then walk away? The walk away provisions in the agreement are what they are, and they only run towards Southern. I will represent to the court that certainly if the county wanted to call it off, Southern doesn't want to be anywhere, that it's not wanted. And they would have worked that out.
Sure,
But
for a small fee, yeah. In response to Judge Wilkinson's question, he gave you the benefit of the doubt, I guess, in suggesting that at some point, what you are doing here is in compliance with, or this agreement is in compliance with Section H. But Section H provides that each agreement shall contain provisions regarding remedies for a breach of those responsibilities on the part of the private enterprise. But here the agreement provides only for remedies available to Southern Power.
yes, Your Honor. And what I would suggest to the court,
Not to the county. So how can it possibly comply with Section H?
Your Honor, what my best response to the court on that point is that this clawback concern, recapture concern, there is historically, if Your Honors read the Moretti case, there is great flexibility to allow partners to come up with a capital investment like this. But what I would suggest to Your Honor is that this provision is there to prevent the county and governments from being abused by their private partners. We have done everything right. It is not meant to be weaponized against those who have done everything right.
So would you say, no, it's not in the agreement, but we act honorably, and so there's no need for this to be in our agreement? Is that what you're saying to me?
No, Your Honor. What I'm saying is that there is, so to be perfectly clear about this,
Right.
there is no recapture issue, period, full stop, because the county has no financial obligation to Southern Power until we sink $300 million in the ground and turn the lights on a fully operational 720 megawatt plant. The county has no risk whatsoever, full stop. So that's why I say it's entirely improper for the county now to try and essentially weaponize a subsequently enacted statute that is meant to protect.
Excuse me, but we keep skipping over this big point, and you come back to it. You can come back to it in rebuttal, but we're talking about a waiver of sovereign immunity here, and in order for the county to waive, for you to successfully pursue a waiver of sovereign immunity, there has to be a contract. And, you know, that really lies at the heart of all of this, because there's no waiver of sovereign immunity if there's no contract. Now, I would like you to address that on rebuttal. You've tried,
Yes, sir.
but I'm not sure it's there. And we've given you a lot of extra time. If either one of my colleagues has a further question of you, it's okay. Judge Mott, do you have any further questions at this point?
No, I've done a lot of talking, but I think Judge Harris might have
No,
something.
I'm good.
All right. Okay, thank you.
Thank you.
Mr.
Good morning,
Ryan?
Your Honors. May it please the court. My name is Grant Osborne. It is my privilege to represent Cleveland County, North Carolina, the appellee. The company has said that this appeal is about restoring trust in good government. We agree. Trust in good government requires this court to enforce clear statutory law that's designed to protect taxpayers from expenditures of tax dollars that don't comply with protections mandated by law. We're talking about a law that was in place long before the contracting issue came into being. This deal does not provide those protections. They're clearly spelled out in subsection H. The alleged contract, which did not arise until 2012, given the nature of this alleged contract, clearly violates subsection H. The settled law of North Carolina provides that the county cannot lawfully comply with a contract that from its inception has been illegal and void.
Can you talk to me about the effective date argument that your colleague on the other side is making? What does that mean? It does say effective date, July 24, 2007. I don't think that anyone disagrees that that was the day that the agreement was signed, and the parties clearly thought they were entering into something, and that the applicable law was the law as of July 24, 2007.
Yes, Your Honor. This argument about the effective date is really an argument about waiver of illegality.
Waiver
of illegality of the contract. The idea that parties to a contract could pretend that a contract existed before it existed is simply a way of saying we would like to exempt ourselves from the settled doctrine that the law that exists on the date on which a contract is made is the law that applies to a contract. That's fundamental contract law in North Carolina, no doubt elsewhere.
But what part of what I think they're claiming is that this is a unilateral contract, and that North Carolina recognizes the law of unilateral contracts.
Yes, sir.
And that, all right, and that what was tendered here was on this agreement in early July. It wasn't a full-blown contract, it was an offer. And that the offer was accepted upon performance. And at that point in time, it became a bilateral contract when the early July offer was accepted and the rec in early July. Lateral contract, it became a full-blown contract when
you were about to give us 3 dates. I'm sorry, I'm a little bit confused. So there's the date of the agreement, there's the date of subsection H, and then I assume the next date you were going to give us is 2012.
Yes, Judge Harris.
And in 2012, is this what happens? Southern, the power company performs. So now there is an agreement, but the agreement is invalid because of subsection H?
That's exactly right, with one qualification, Your Honor. The only qualification is that, to make sure that we're precise in a terminological sense, there was no agreement in July of 2007. There was an offer.
I'm sorry, the offer, right? I just meant capital A agreement. There's this document in 2007. It becomes a contract in 2012, but because of the intervention of subsection H, that is not a valid legal contract. That's your position? That's
exactly right, Your Honor. Because, as Judge Wilkinson said, our law does recognize the possibility of a unilateral contract, which is a fundamental contract notion. A party can make an offer. The offer is not binding on anybody until the offer has been accepted. Obviously, to the court's point, every contract requires offer, acceptance, consideration. Offer occurred on July 24, 2007. Acceptance and consideration occur in the same event in the context of a unilateral contract in the form of performance in accordance with the offer. That performance is acceptance and consideration. The plaintiff's problem is that kind of performance did not result in a valid contract by the time it came about, because more than 5 years before, the legislature had adopted a statute.
So let me ask you let me tell you my concern. I understand your argument, and I understand why the timing in this case left the power company with lots of notice, because subsection H was passed shortly after the offer. But what if subsection H had been enacted in 2012, the day before they're about to cut the ribbon on their power plant and start providing power? Then they'd really be up a tree, right?
Well, under the doctrine of unilateral contract law, performance must take the form contemplated by the offer. And if by the time performance has been rendered, the contract contemplated by the offer is unlawful, then I think that Southern Power would still have the same problem it does.
The same result.
They would have the same result. Fortunately, for our argument, frankly, that is not the case. The law in question took effect 37 days after the offer was made. It took effect more than 2 years before the plaintiff claims to have turned a shovel of dirt on this plant.
But there'd be no protection in my hypothetical. Never mind.
Excuse me, Judge Harris.
It's okay, go ahead.
How do we know that they never performed? Is it undisputed at this stage that they never provided the investment, or they never invested the funds, or that they never provided the employment or jobs? Or how do we know that they didn't comply with subsection H when that power plant went up?
Well, I've heard two different questions, Your Honor. The first goes to whether the company performed. For the sake of the Rule 12 motion, of course, the court must assume that the company performed as it pleads in the complaint. We're not taking issue with whether Southern Power did what the complaint says it did. The issue is the legal effect of what it claims to have done. To your second question, Your Honor, the issue is what does subsection H require? Again, the only document in question here is the offer made by the county, drafted, as we heard, by Southern Power's counsel. That document is accompanied by nothing else that describes the terms and conditions of the deal. Subsection H explicitly says, in effect, thou shalt include three different things, which I could go over, but if the court has them in the record, says this is what such a contract must include. The contract, again, is a function of offer, and then more than 5 years later, acceptance and consideration in the form of performance includes none of them. There is no, in my opinion, no plausible argument that the contract does include any of them. Thus, we have.
Why do you say, I want to say, why do you say that they didn't comply with subsection H when the plant was up and running?
Certainly, Your Honor.
Obviously would have had to employ some people by that time, and they obviously would have had to invest funds by that time. So why are you saying that there was no performance of such a nature that would comply with subsection H?
Your Honor, we're not suggesting or saying that there was, quote, no performance. I'm not implying that no performance is critical to our argument. What we are saying is that the company, and for that matter, the parties, have not complied with the dictates of subsection H implemented by law that was enacted.
Why have they not complied?
Because such a contract, certainly. Because
I think it would help if you looked at subsection H.
yes, I'm having.
That's what is missing in the discussion here. It requires certain recapture
yes,
items which just aren't in this agreement.
That's correct, Your Honor. The language of the statute says that each economic development agreement shall clearly state the parties' respective responsibilities. The offer in this case states no responsibilities of the plaintiff. Does it state conditions? Conditions of entitlement to payment? Yes. But does it state responsibilities? That is something the company must do? No. Next, subsection H says that each agreement shall contain provisions regarding remedies for a breach of those responsibilities by the private enterprise. Does the offer document, again, the only document in question here, does that document include any such provisions? No. The word breach never appears. The word remedy never appears. The word remedies appears once with respect to the rights and remedies of the plaintiff, not the county. Finally, Your Honor, subsection H says that the provisions regarding remedies for breach shall include a provision requiring the recapture of sums appropriated or expended by the county. The offer document includes no such terms.
Can I just have a question about subsection H. So is basically the gist, or at least the effect of subsection H, is you just can't have these unilateral agreements anymore because they don't have.
Whether parties can enter into, I think, given the way the statute is written, a unilateral contract in this context could exist. But whether
I'm sorry, I don't know what you mean by begs the question. Does it say? Okay.
Because seem to be mutually exclusive.
Is there some reason to think, like, why did the legislature think that this kind of a contract, which does seem to offer very good financial protection?
We know this. If you look at subsection H,
is not the other parties trying to, it's the county itself, it's the governmental agency. So that I haven't found a case like that has this wrinkle in it. Have you?
No, Your Honor, we have not either. But to answer your question as to whether that declaration by one party to the contract, the county in this case,
party that is going to be
party who's allegedly, let's assume the county said this is what such a contract must include, and the company, the plaintiff, was on notice of that and cannot claim, frankly, with a straight face, to have been fooled or misled by Cleveland County. Law is and comply with the law.
But counsel, I mean, you have to. I hear what your judge suggested. This case does look pretty unfair, and it does look at capital A agreement, the original promise 2009, just to make sure we're all good. Subsection H precludes this, so we're going to keep the plant and you don't get the incentive payments.
Yes, Your Honor. I understand.
So do you have like a response to just how bad this looks?
Sure. To the company, and as I think Your Honor may be suggesting. There are two reasons why that is not true. Number one, factual. Number two, legal. This whole fairness idea blindsided here. They cannot say that. This is a company that has millions of customers and spent millions of dollars. They cannot claim to have been blindsided by changing the law 37 days after the offer was made. Likewise, this law, subsection H, became the law more than 2 years before the plaintiff claims that it broke ground. The company does not even work in August 30, 2007. That argument cannot be
I
made
asked your
possibly.
colleague a few minutes ago, and he said that they were doing a lot of thinking and planning.
Yes, we wouldn't know about that, but it's just not in the pleadings. No matter what the parties may do to try to accomplish that result.
All right, let me ask you just one final question here. You're
Yes.
saying, as I understand, that compliance with the law here and performance, and but particularly compliance with the law here, series of written documents, of obligations, as outlined and detailed in section H or subsection H.
That's exactly right, Your Honor. That's what the statute says.
It's got, in other words, the compliance and the performance is not just a shovel in the ground or question.
And I will get back to the gating point, backward or clawback. To return to the gating.
Follow up on what you just said.
Yes, Your Honor.
So if this case was before the Supreme Court of North Carolina, you would win. Is that what you're telling us?
I believe we would, Your Honor.
Well, of course, you chose the forum, didn't you?
We did, and that's yes, Your Honor. We chose the forum. We chose the forum. We chose the processes and the independence of the federal courts, Your Honor.
As a federal court interpreting state law, not to undercut, so it's not something we, what I'm thinking about is that the state law before us and not having localities taken advantage of by contractors who promise this and promise that and don't deliver public policy.
I agree, Your Honor, and I appreciate those comments. I will address the relation back point, and then I want to return to why there is, Your Honor. As to the relation back point, we know
positions. So thank you. We will head now into our second case.
Sure, I fully understand.
I thought that part of your case was that the company asked for too many or too often the records with regard to the prescriptions.
It's too much in the way that.
Sought that, but request the documentary evidence as a part of discovery all the time. And if the legal in dispute left as discovery matters are to district judges, unless they.
This isn't a case. Chris was concerned that employers would invade employees' privacy and would discriminate against disabled employees based on their records. And so it limits when an employer can get records. No one disputes here that Norfolk Southern had a right to some records.
But counsel, what it's been
to show that he could ask an employee, "Hey, give us your medical records, but not do it from the medical director, not even do it from the nurse who decided which records to get. But have a caseworker."
They don't have it.
Southern wanted were.
It was not presented to exist, surely.
Yes.
Okay. So your answer is yes.
Yes.
It wasn't this great big bundle at the end. It was earlier than that.
For you a fact about this, he says he's having me talk to different people, but before his termination, he shows up at his hearing and he produces all of those records in person. And so there's a dispute on when they got them, but we know by the time they have the termination, they have all those records.
And you don't know which are which. You don't know when just came in at the hearing.
So I know what Norfolk Southern says of the case. Part of the problem.
Why don't you know? It's just, I mean, this is your client.
Well,
they were your records.
I don't know how I would prove Norfolk Southern received a fax.
No, you would know what came in at the hearing.
Oh, at the hearing, yes. Yeah, we know what all the records that came at the hearing, we know what they have, yes.
And I'm sorry, and those records did include records about that he was taking the codeine at
Yes.
at some particular interval consistent with the doctors?
Yes, and why he was taking that had nothing to do, that he wouldn't be taking it at work. It's for a
Right,
skin
for the
infection on his
skin,
back.
Right.
That would no impair his ability to work.
All right, thank you very much. Judge Motz, Judge Harris, do either one of you all have any further questions of Mr. Thompson?
Thank you,
I
Judge.
think we should talk for a minute about the Achilles tendon
Oh, yeah.
situation because it's somewhat different. And we have no other argument this afternoon or this morning, Judge Wilkinson.
Certainly. So for the Achilles tendon, the testimony in this case by the only expert is once they got the return to work note from the doctor, as well as the FCE examination, so the functional capacity examination results, it was clear he could work and there was no need for further medical documentation.
But I thought the capacity function report said he had trouble with stairs and he has the calf issues. Why isn't, if he's having trouble with stairs, why aren't, and climbing stairs is part of the job, why aren't they entitled to follow up on that?
There was nothing to believe in there. He couldn't climb stairs.
What did it say, that he had difficulty with stairs?
And his foot was intruded or something?
My recollection was stiffness, but it could have been difficulty, but there was nothing to indicate he could not do it. As the only expert in this case said, the proof's in the pudding. He was returned to work by his doctor. The functional capacity examination said he passed, whether he had difficulty or not, he passed.
The proof in the pudding is if you put somebody that can't do the stairs fast enough and they need to for the safety of the people in the train, the pudding's not going to be good. I just don't, I do think safety concerns have to outweigh concerns, individual concerns about when you would like to return to work.
Your Honor, we agree completely, but we also think those decisions need to be made by medical experts. And here, the medical testimony is he could safely do his job. And let's be very clear, there is not an expert opinion to the contrary. Even their medical director says she never made a determination whether he provided enough records to safely do his job.
I'm sorry, so he has difficulty negotiating stairs and he's limited by calf weakness. But your position is that upon receiving that information, the company has no choice but to say he's good to go.
It's not a matter of my opinion. The only medical expert says after the FCE, it was clear he could do his job after being released to return to work by his treating physician. And after the FCE.
But the treating physician, does a treating physician have job, a description of what the job demands are from the company? Like, how is the treating physician who says he has difficulty negotiating stairs, how is he in a position to put together whether that difficulty is going to be a problem on the job?
So this goes back to your Honor's original question, which is a procedural problem with how Norfolk Southern handled this. In one of the notes from the doctor said, if you have any questions, call me. That's what should have happened. Norfolk Southern's medical director should have talked to the patient or the employee, Michael Coffey. If there's any concern, should have called the doctors.
Don't you understand? You're a lawyer. Often you want something in writing rather than to hear it because recollections change on what was said. But when something is in writing, there it is. We can agree.
Sure.
So there would be a very good reason while the railroad is worried about safety that it would want a response in writing.
Sure, but you don't put the onus on the employee who is not a medical expert to do that. And so if you want it in writing, you call doctor and say, hey, we're sending you this job description, this form. This is how it's typically done. I mean,
I understand what you're saying. It does seem like this was a quite onerous kind of document production they were putting Mr. Coffey to here. And I do understand that it can be difficult to deal with the medical establishment. I have two concerns I guess I would invite you to address. One is that I can understand, though, why an employer might think it is more protective of an employee's privacy not to be calling around to their doctors. And the other is I don't see anything in the statute that goes to the process by which information is collected. As you explain, like this provision is about protecting privacy. It's a limit on what employers can ask for and find out, but I don't see anything in it that goes to the process. Once you've established that there's no privacy right being violated, with respect to the reasonableness of the information being sought. I just don't see anything in here that talks about the process by which it's gathered.
And I agree, there's nothing in the statute, but what there is a reasonableness component.
But the reasonableness seems to go to the reasonableness of the need for the information, not the reasonableness of the method by which it is collected.
It's difficult to divorce those two things, because what you do as a medical director or as a doctor is you talk with the person to determine what information do I need. Not talking with the employee, not talking with the doctors makes it impossible to determine what you actually need to obtain in order to make a determination. And that's really the problem here, is neither the nurse, neither the medical director talked with the employee, talked with the doctors. They left it to, a third hand. So 3 people were removed without, making the proper medical judgment, having the proper.
But you're making these categorical or these conclusory statements that, we provided everything that was asked for. The records exist and we provided them and all the like. And the railroad will undoubtedly come and say, no, you haven't provided them. We haven't gotten near enough. And that's the only neutral party in this whole business, where you just have these a clash of conclusory statements, and to some extent is a district judge. And I just don't understand why it presents anything more than a classic discovery dispute, which can also present questions of privacy. But
this is not
would you mind doing this, taking some of this up on rebuttal, because you did reserve some time?
Sure, Your Honor. May I answer that one sentence first, please, though? This is not my conclusory sentence. Those are the only expert in this case's conclusions, not mine.
Well, I know the Second Circuit says bringing on an expert doesn't necessarily create an issue of triable fact, but we can go over that on rebuttal if you want. All right, is it Mr. Spain?
It is, Your Honor. Good morning. May it please the court, my name is Brett Spain, and I'm here on behalf of the appellee, Norfolk Southern. I'll admit I had prepared a slightly different argument than the way this has gone, because in my view, there were both procedural and substantive issues that needed to be addressed here as far as the standard. And as we pointed out, the district court did a full.
You're in control of your argument.
Certainly, Your Honor, and I had anticipated some discussion of the McDonnell-Douglas standard in the opening argument, and there did do analysis on McDonnell-Douglas and did the analysis that the court is looked at today on the medical inquiry standard. It did both of them, and the plaintiff has only appealed the latter of it, and under accepted appellate procedures, he has to present each argument, each independent grounds on which the court relied in order to prevail.
I don't understand your argument on this. It looked to me like the district court thought, rightly or wrongly, that the plaintiff was bringing 2 different claims, a standalone medical inquiry claim and also a more sort of general disability discrimination claim, ruled against him on both, and he's appealing one. Why isn't that fine?
I don't think that's exactly what occurred there. The plaintiff, in his motion for summary judgment opposition, specifically said that the McDonnell-Douglas standard does not apply to any of the
That's why I
claims
think I'm not 100% sure that the
Right.
district court was right, that there were 2 separate claims in front of it. But nevertheless, the district court went ahead and adjudicated 2 grounds, said he can't prevail on either, and he would like us to review the holding that he can't prevail on the medical inquiry claim, and that seems fine.
Well, I think that's what happened, is that he said that the McDonnell-Douglas standard doesn't apply to either of them. The court said, you're wrong, but I'm going to go ahead and do the analysis as the medical inquiry claim as part of the prima facie case. Is it job related, consistent with business necessity? And then also did the McDonnell-Douglas part of it, which we think is appropriate. That was an express holding of the trial court, which has not been appealed and is an independent ground to affirm it.
Well, in case we don't think that gives you the whole game, maybe you could
Certainly.
address what was.
Like I said, I'm here to prepared to do both. The reason why I think that the plaintiff has changed course here and focusing just on this medical inquiry and that standard is because he knows there's not a shred of evidence that Norfolk discriminated against him on the basis of disability in this case.
Well, let me tell you, I mean, I don't think he's bringing that claim. I think he is limited at least now, we are only talking about a medical inquiry claim, but this is, I'll just tell you my concern about this case. It sure does look like this was an amazingly onerous process that was imposed on this employee. It is hard to get information out of doctors. It would have been a lot more straightforward for the employer if it had some residual questions after 400 pages of medical records were produced, just to go directly to the doctors, to give the employee, maybe Mr. Coffey, a form that had the questions that he wanted, that the employer wanted answers to hand to the doctors. Like, this was not handled in a particularly efficient way, which is how you can end up with 400 pages that don't answer the question. And so I guess my sort of free-floating concern about this kind of case is that if an employer did say, want to not bring back an employee because he had a bad ankle, it wouldn't be that hard to say, we'd like to bring you back, but we're going to need 10,000 pages of records, and then we're going to like fly spec them to make sure we have everything, and then we're going to go back and ask you for more and more and more, and use that as a pretext not to bring someone back. So that's sort of my concern about what happens if we don't put any check on the method by which employers can get this information.
Your Honor, I understand your concern. And I think there's both a legal question that Your Honor raised earlier in the opening argument, whether there's a legal duty or anything in the law that says this is how you have to do it. And the court is right, there isn't. But getting to your more practical question of should there be, or should there be something that a process? Of course, Congress can say that there is, but in this case, what we were talking about was a specific list of requests. There were letters that were sent out in April of 2016, July of 2016, saying, these are the specific records that we need. That's what, and he was instructed, if you have a problem, take this to your doctor, show them what the list is, and get these records. It was not overbroad. It was not unclear what the records were. It was, here are the information that we need. And if you look at the letter, the requesting records, for example, on the Adderall and codeine, each of those requests are specifically tailored to meet the federal regulations that the railroad has to comply with in order to make sure that they're not putting an employee who is not at full mental capacity behind the engine of a train. For all the reasons that Judge Wilkinson identified, that this is a very serious matter. And this is one thing that the parties don't dispute. Locomotive engineer is one of the most safety sensitive positions that there is. If there is a derailment, you can have loss of life, property damage, environmental disasters. This is something that the railroad should not try to be, take a risk that it's going to put somebody who is not safe to return to work because he might face a claim that it is asked an overbroad request. And so what it did is it prepared these letters, said, here they are. Gave them to him in April, gave them to him in July. Take these to your doctor. This is what we need to get you returned. And the undisputed evidence here is those were just ignored. It wasn't until the summer of 2017, a year after the first request, that the plaintiff even produced a single document. And then it was, as the court is asked about the records and what was produced, there was only 35 pages that the plaintiff could in any way prove had been sent or received by Norfolk Southern. His records matched Norfolk Southern's records on that. What he said he could identify, he could document was sent exactly what Norfolk Southern said it received, 35 pages. It was when he showed up at his disciplinary hearing with the 403 pages that he came with those records. And even then, the railroad gave him the benefit of the doubt, looked through the records to see, all right, does this contain at least the minimal information that we need to return you safely to work? And it was only after it was determined that he did not do that, that they terminated him. And that wasn't even the last step, though. And
I guess if you, counsel, I guess if you just wanted to get rid of someone or dismiss someone, you wouldn't go to all the trouble that you went here to trying to, the way I read the record, and I looked over a lot of it, is that they were just trying to, they hadn't made a decision. They were trying to get information on which to base a decision.
Exactly. That's exactly right. And there's not going into it trying to terminate him. They're trying to see when is he safe to return to work. And it's a year passes that he ignores the first request. He's completely ignored the Achilles request. It's like, we actually need to, you say you want to come back. We actually need this information to determine whether it is safe for you to return. It's
So
not.
is he working during this time?
He worked it for a little bit at the beginning, but when he went on the Achilles, he was not working. He was out.
Well, how far along was that after the original inquiry?
I think he tore it on June 10th. So he was,
When does it begin? I don't, you have to give.
I'm sorry. The first request was April 25th, 2016, but he was permitted to continue working because he had prescription at that time and so it was verified negative. He was allowed to continue working, but Norfolk Southern had to ask the questions that it did. But from June 10th, I believe, from on until, well, he never came back. He was out of work. And so at that point, saying, all right, we were serious. You have to, we have a little leeway on this stuff because you have a prescription, but we have to determine whether you're using it correctly. And as I heard Mr. Thompson say, well, yes, he had that information in the records. Where? He still hasn't pointed out, didn't point out in his brief. This is the part of the joint appendix where you're going to find where I provided all that information, or that the plaintiff did. It's not there. We included the letters in our brief, the actual letters from his doctors on the 2 prescriptions, because we wanted the court to see what information did he provide and what information did he not provide. And in one of the cases, it didn't even say what the condition was that he was being treated for. Neither of them talked about the dosage, what the dosage was whether he was actually observing it, and the side effects. What are the side effects? What are they, generally, what are the side effects that he's experiencing? How long are they being experienced?
I'd ask you just a quick question. Why would the doctors know whether he's observing the dosage amounts? Is the idea that if he's not, like, they would know he'd have to refill prescriptions more often? I mean, wouldn't it be easier just to ask him?
You could ask him, and to some extent, you're relying on the plaintiff being truthful in his self-reporting, right? And it could be to the doctor, it could be to.
How would the doctor know?
The doctor certainly can't say, I can swear that this is all he's doing because I'm not in his house every day observing him doing that. But the doctor would at least, before this issue would come up, there would be a history there of, all right, here's what I prescribed. When did he come back for more medicine? When did it need to be refilled? Is he doing it on the schedule that he's doing it? Is he doing it too much? Does he come and when he presents to me say, oh, I need more? Does it sound like he has a problem with it?
But the specific question to the doctor is the person adhering to the schedule?
Right. And the doctor can give, it's just the doctor that is seeing him for this condition could give at least his or her opinion on whether that's being followed and whether it's working. You could say I don't know, but it would also.
What if the doctor said, I don't know? Would that be satisfactory for then what would the employer do?
It's hard to say because the regulations, you can't opt out of them, right? I mean, the Congress has said, this is what the railroad has to consider. And if it doesn't have the information to consider those issues, it cannot allow a locomotive engineer to be a locomotive engineer.
Yeah.
And so you're in a very difficult situation, but certainly you go to the doctor who's treating him and say, this is what we need to know. And we put those letters in our brief because they do not contain close to the information that's required.
Where else would they go if the doctor didn't? The doctor's got to be the best source, but it may well be, for the reasons my colleagues mentioned, it may well be an imperfect source, but it's the best source. I don't know, where else would you go if you don't go to the doctor? I mean, where else would you satisfy the obligation set forth in federal law?
I agree, Your Honor. And the plaintiff's position is, well, I have an expert who's going to tell you what the law is. And according to this expert, all you have to do is talk to the employee. And you have to presumably accept whatever the employee says. And if the employee says, no, I'm good, here's my prescription, here's when I use it, you're not allowed to ask any further.
Wouldn't it be better if you, I have read the record in this case, and it's, I do understand everything you're saying. Is there some reason you don't just give the doctor a form that says, like with boxes, like, is there any indication that this patient is not using it? Because I could see, as if I got this form as a doctor, like, but I don't know whether he's using it as prescribed or not. And I would just leave the question blank, and then the person would get fired. But if I got a form that said, is there any indication he's not using the medication as prescribed? Is he refilling prescriptions more often than he should? Then I would check the boxes.
Right. Your Honor, I don't know all the practical difficulties that would go along with that, but certainly a form presumes that one size could fit all for all these kinds of inquiries, that you could have a form versus letting the doctor explain to you as the employer what the condition is, what the specific circumstances are, where you would want more than a box that's been checked. You'd want an explanation of what is the condition, how serious is the condition. And could you, the next thing you know is we gave a form and somebody says, well, your form was deficient. You didn't ask the right questions, and you let this person come back to work because you didn't ask the right question. And we're, as the court has observed, between a rock and a hard place here. This is an extremely important position that the plaintiff held as far as safety is concerned. The federal regulations put the burden on the railroad specifically, not just a general employment requirement, on the railroad to find this information out. It was not provided, period. And that's why he was terminated.
Okay, can we talk a minute about the Achilles tendon?
Yes, Your Honor. Did you?
Do you have an argument to?
Certainly, the Achilles tendon, the same thing. He was out in June, and then advised of the railroad medical department in July. They sent out the request for information. Now, as the court has observed, that the standard for whether it's job related and consistent with business necessity is whether the employer has enough information that a reasonable person would question whether the employee could safely perform his duties. In this case, the plaintiff self-reported that he couldn't perform his duties. He sent in a list, I'm out. I've torn my Achilles tendon. I cannot perform my duties. I am out. And he left. He didn't come back. It was the following year when he said, okay, I think I'm ready to come back, when all the further round of letters came back. But certainly the law is clear that when an employee is out for an extended period, that the employer is allowed to make reasonable inquiry. And under these circumstances where he has told Norfolk Southern, I can't work with this condition, given the duties that I'm not sitting at a desk, I can't go on crutches and get to my job and do it. I can't do my job because of my injury. The railroad certainly is entitled to then say, all right, we need to know more about this to make sure that you actually can, that you have healed to the extent.
And he gave you more?
Right. And so they say, here's the records that we need. And what the plaintiff has come back and said, well, I went to my regular doctor. He gave me a right to return to work letter, a 2-sentence letter. The law is clear. That's not sufficient. That the employer is allowed to make its own inquiry and doesn't have to rely on a return to work letter.
Well, didn't he do
the FC? Yes, that was the next thing. The other thing he pointed to is my functional capacity evaluation that was undertaken. And there isn't anything in the record that indicates that the person who did that evaluation was aware of his duties and all that it entailed.
Well, ultimately, this comes down to a judgment call on your part, and the railroad's the one that's making the judgment. And I think you're entitled not to infinite latitude, but I think you're entitled to some latitude in making a judgment, because you are the one who has been charged by federal law with maintaining the safe operations of the trains. And so I think you're entitled to not unlimited latitude, but I think you're entitled to substantial latitude where this kind of value is concerned. The conundrum rises: the more information you get, the better judgment you can make. And that faces resistance, because the more information you want, the more someone is likely to resist on the grounds that these are personal medical records. And it's a dilemma, but I don't see any way around it, because the truth of the matter is you need more information rather than less in order to make an informed judgment, and not a judgment that just at bottom is a complete leap of faith. So that's, you need comprehensive information, and at the same time, you run into resistance on that very point. But I don't see any way around it.
Your Honor, I think you're exactly correct that this is something that you have to have latitude in what can be requested. You have to have some a substantial, reasonableness in considering what you've gotten back and to see whether he's qualified. And the functional capacity evaluation that the court was asking about, it did not give him a clean bill of health. It specifically said he had difficulty with even regular stairs and that he had calf weakness. And he doesn't dispute that an essential part of his job is getting off on the train multiple times a day, walking over uneven balance. He's got to be able to do that. And that's a good example.
So what we also have is, and he keeps talking about, is his expert,
Right.
who is the only doctor's testimony that we have.
Certainly.
And that's all you need.
Your Honor, I know that's all he has. And
He has his own ability, he says, and he has this functional capacity kit.
right, no, I understand that. What I meant was that's the only evidence, so it's the only legal authority that he has.
So you don't have an expert.
No, we don't have an expert,
So
but
then what we are facing is one expert. So does that create an issue of material fact?
it does not, Your Honor. What the expert is trying to do is tell the court what the law is. And this is, once you have this, the law doesn't allow you to do any more than that. Everything that he's talked about is exactly that analysis. Well, once you had this, the law doesn't allow you to ask for more than that. The trial court examined this exactly correctly. What the trial court said is, I've looked at that evaluation. It says he still has trouble climbing stairs. It says that he still has calf weakness. It was reasonable under those circumstances for the Norfolk Southern to continue asking for records to make sure that he could do that. That's the analysis. What does the law allow the employer to do? What the plaintiff has offered through this expert is, what his personal steps are. This is what he thinks should be done. This is what he would have done. This is what he did when he was in practice, and not a hired expert. And that's not what the law says. As the court has already pointed out, there is no procedure that's mandated by the statutes. There are no steps that are mandated. There's nothing in the law that says you have to talk to the employee at the beginning. At the end, there's nothing that says that the employer has to go directly to the doctors. And there's a lot of good reasons why you wouldn't want employers going directly to doctors. As Judge Harris pointed out, this is a statute that's concerned with privacy, and to impose liability because the employer here didn't go and then start having direct conversations with the medical professional, it is hard to accept. And I don't think it is required by the law. I think the trial court judge got this exactly right. The trial judge considered every argument that the plaintiff raised, specifically analyzed whether he had produced records that were required to be produced in order to return to work, and found that he had not. There's not a factual dispute here. We think this is a straightforward case and would ask the court to affirm on that basis.
All right. Thank you very much, Mr. Spain. Hold on, Judge Motz. Judge Harris, would you like to ask further questions of Mr. Spain?
No, thank you.
No, thanks.
Mr. Thompson, you have rebuttal time.
Thank you, Judge. So let's work in reverse order because I think two of the conditions are easy to knock out. Let's start with the FCE. Judge Harris, you asked me about that. Let's be very clear about this. This is not just a case of one expert having said that Mr. Coffey could safely do his job. Both of Mr. Coffey's treating physicians did as well. Concerning the FCE, Dr. Payne reviewed the FCE results and re-examined Mr. Coffey on 4/18/2017, at which time she opined he was ready to return to work. She officially released him to full duty with no restrictions, limitations, or required accommodations of that date. She provided no prescription refills for Norco or any other medication related to his Achilles tendon injury and surgery. In other words, the only doctor that examined him after the FCE said, "You're good to go." Norfolk Southern's doctor didn't even bother to talk to him. Let's move on to the next condition, the ADD. I don't think anyone here is really taking issue with him taking ADD medication. In fact, that helps him better do his job. And their own medical expert, again, who never talked to Mr. Coffey, admitted she had the prescription. So we're really talking about the pain medication, the Tylenol 3 medication. About that, Dr. Jimenez, another treating physician, it's his primary care physician, responded to a request from Norfolk Southern on 7/5 of 2017, confirming that Mr. Coffey infrequently took Tylenol 3, which she prescribed for flare-ups for a chronic back condition. She and Mr. Coffey had an agreement that he would not take the medication just prior to or during work hours. As with his previous treating physician, she noted no issues regarding misuse, abuse, or diversion of this medication. It is not just Dr. Kevin Trangle, the independent medical expert. It is both of the treating physicians. It is every doctor who has talked to or examined Mr. Coffey has said he can safely do his job, and Norfolk Southern had no reason to believe otherwise. Now, can Norfolk Southern inquire? Certainly it can. And let's look at the circumstances under which it can require. That's governed by 49 CFR 219.103. And what it says is a physician designated by the railroad has made, quote, a good faith judgment, end quote, and it continues on, that the employee can safely do his job. So the employer has to make a good faith judgment. And to the court's question, well, what constitutes a good faith judgment for a doctor? That is an expert question. I can't determine what's a good faith investigation by a doctor because I'm not a doctor. That takes a doctor to determine. The doctor in this case, the only expert in this case, said that what Norfolk Southern was not in good faith. It was not a good faith judgment. They were asking for records they did not need because Mr. Coffey provided every reasonable record. And that is not Kevin Trangle's, just his personal steps that he took. Rather, he talks about a standard of care in that community, that this is what doctors in that community do. And so the only testimony in this case that the standard of care is to talk with the employee, and then based on what the employee says, talk with the physician. Here, Norfolk Southern's doctor didn't talk to anybody. Norfolk Southern's nurse didn't talk to anybody. The only thing that happened is they had a frontline clerical person talk to Mr. Coffey and say he needed to get certain records.
When you're talking about expert testimony, are you familiar with Bay versus City of New York, which is a Second Circuit case that came down just this year?
I'm not, Your Honor.
Well, what it dealt with the question of expert testimony as it relates to federal litigation and to federal regulation. And they go on at some length and indicate that expert testimony, the Second Circuit squarely rejected the proposition that expert testimony could create an issue of triable fact, where a requested accommodation or a request as here was permitted or was authorized or indeed required by federal regulations. In other words, I don't think just bringing on an expert, and the Second Circuit is really clear about this, where the federal regulations are clear, bringing on an expert does not create an issue of triable fact in and of itself.
And I'm by no means arguing that just because we have an expert, that creates a triable fact in every case. What I am saying is when what's at issue is whether a doctor has made a good faith judgment as to whether an employee can return to work, that is an expert question.
Can I ask you a question about so you're talking right now about the railroad regulations,
Yes.
right? Yeah, and I do understand that a big part of the defense in this case was we were required to make these inquiries because of the railroad regulation. But is it your position? I mean, I would have thought that there might be inquiries that would be not required under the railroad regulation, but still permitted under the statute. That there would be some space between those two things, that you could have a legitimate work-related business necessity need for information that you are not required to get.
Certainly.
Okay.
The federal regulations just set the floor. Certainly they can go beyond that.
Okay.
The problem here is that every medical expert, both the treating doctor, the primary care physician, and the independent medical expert all say these records demonstrate Coffey can safely do his job. You had enough. You didn't need anything else. And the real problem is nothing else really existed. I still don't know what record they wanted. He's been reinstated by a public law board. He hasn't been able to go back to work because we still don't know what record they want. Their medical director still has not talked to him and told him this is what we want. Their medical director still has not called his doctor and said, This is what we want. You can't put the onus on a layperson to go out and get medical records they don't understand and then be upset with them and fire them when they don't do a good enough job. There has to be something more than that.
All right, thank you very much, Mr.
I just have one question that I've been on.
Absolutely.
So what is the basis of your claim? Are you making a claim for discrimination in firing?
It's our position that an impermissible medical inquiry that results
Yes, I
in a
understand
termination.
that claim.
That is our claim.
Is that the only claim that's before us? It seemed to me in the district court, you made a number of other claims.
We think the district court analyzes a discrimination case. I don't think it is that. I mean, they fired him for not producing the records. I don't know that what was in the records.
So you say that your only claim is dealing with these records. Is that right?
It's an impermissible medical inquiry claim.
So
Yes.
I can't hear you.
Yes, it is an impermissible medical inquiry claim.
Okay.
It seemed like before the EEOC, at least, the claim was slightly different, that all of this business about the records was a pretext for firing someone they wanted to fire because he had a bad ankle. But that is not the claim you're making now.
So part of the problem is this theory of liability under the ADA is not well developed. There is not a lot of cases on impermissible medical inquiry.
Mhm.
It is our position that if an inquiry is illegal and you fire somebody for not producing a record you weren't entitled to, that falls under impermissible.
But so your position in front of us, I really am just trying to clarify, this is fine, is that, oh no, he was fired for not producing these records. And the reason that's illegal under the ADA is because they weren't entitled to the record. Your position is not, no, he was not fired for not producing the records. That's a pretext. He was actually fired because he has a bad ankle and he's old.
No, we think
Okay.
he was fired for not producing the records.
Thank you.
Any further questions?
No, thank you.
Thank you, judges.
All right, Mr. Thompson, Mr. Spain, we thank you both and appreciate your arguments. And sorry we cannot come down and greet you, but I hope you both have a pleasant afternoon.
Thank you, Judge.
You too.
And we will adjourn court and take a brief recess and then come back in